Good morning. Today I'd like to talk to you a little bit about business organizations. This can be very important because a business organization form can affect significantly the liability of the owners for things that the business does. It can affect their taxes. It can also affect their relationships with people who work at the business and their customers. So let me go through some of the learning objectives and we will talk a bit about this chapter. We're going to first describe the factors to consider when you are deciding on the form of organization of your business. And we're going to contrast the basic organizational forms that businesses select to conduct business and compare some of the hybrid forms. So there are a few forms kind of in between the sole proprietorship and partnership and the corporation. There's some hybrid forms in between that may be perfect for your business. Excuse me. The basic forms are sole proprietorships and partnerships and corporations. So let me give you an example of what could happen. This is from a real case. A young man's father dies. The father owns a nursery business, and an elderly man has worked there for years growing the plants that they sell. The young man is not very good at growing plants, but he feels that he can handle the business that he's inherited otherwise, and so he asks the older man to stay on with him. And he says, as an incentive for you to stay, I would like to share profits with you as our business makes profits. So we'll sit down once every few months and I'll give you your share of the profits. Well, a few years go by and they do this. And then the older man says one day, I think I'm going to retire. Now I want you just to pay me for my half of the partnership. The younger man says, we're not partners. I own the business. The older man says, no, we were sharing profits, so we're a partnership. You can see where you could get in trouble here. So the older man expects the younger man to pay him several $100,000, half the value of the business. There's no real written agreement, and so this had to go to court, and the older man actually won. So it's very important to understand business organizations, understand partnerships, and understand the other types of organizations and why you want things in writing for sure. So after this class, you should definitely know that you want to put things in writing, and you should also probably know that it's only a very rare case that you'd ever want to be a partnership or sole proprietorship. All right. There are also some hybrid forms that are kind of in between. Sole proprietorships and partnerships can be formed with really no agreement at all. They can be formed by just people starting to do business. Now, again, partnerships are better if they are done with certain written agreements and maybe even filings of the names with the Secretary of State, but they can be formed just very informally. Corporations have a high level of formality in how they're formed and operated. There are some hybrid types of business that are kind of in between sole proprietorship and partnership and corporations. And those are limited partnerships, S corporations, and limited liability companies and limited liability partnerships. So they kind of contain some attributes of partnerships, but also attributes of corporations. Closely held corporations are owned by only a few persons. Usually that's a family-owned or family-operated business, but a publicly held corporation is owned by hundreds or thousands of persons. And these types of entities are very necessary for a large company to grow and to have investors. And then the stock is traded on a public exchange. When you are selecting how to organize your business, one thing you'll consider is cost of creation. Certainly, it's cheaper and easier to form a sole proprietorship or partnership, but that's not the only thing that you want to consider. It's more expensive, of course, to form a corporation or a limited liability company, but still, there's some reasons to do it. Another thing is continuity, stability or durability of the organization. If you form a corporation and then one of the shareholders die, the corporation continues. On the other hand, in a sole proprietorship, if a sole proprietor dies, the business dissolves or ends. There's managerial control that you would want to consider. You want to have something in place that determines how things are going to be decided, particularly when there's more than one owner. And you also want to consider owner liability. If you are a partner in a partnership, for example, maybe the partnership owns a retail store, and a customer walks into the store, and unbeknownst to you as a partner, the floor is slick because someone spilled something. The customer slips and falls, breaks his hip, sues your partnership for $5 million. Well, your partnership may not have $5 million, but not only can that customer go against what the partnership has, but if you are a partnership, you have unlimited personal liability for that $5 million. So you can also lose your home, your bank account, everything you own, your car, and you may have to file personal bankruptcy. And so that's very important to keep in mind that owner liability is one of the governing concepts when you're choosing a business organizational form. Now, another situation that you want to consider is taxation. As an attorney, if someone came to me and said, I want to start a business, I would immediately talk to them about some of the first four of these factors, but then I would talk to them about taxation and encourage them to consult with a CPA or their tax advisor to determine what entity is best for them in terms of taxation, because things can vary in terms of state taxes and situation to situation. And so that's a very important consideration. And it's sometimes complicated. So here are some of the factors. The two basic types, remember, or three really, sole proprietorship and partnership versus corporation. They're kind of two extremes. Now, the sole proprietorship, there's really no formal documentation needed. It requires a business license, though. And as long as the proprietor desires, that can continue, but it can't be really transferred to others. The proprietor controls it. The proprietor is personally liable for all debts and liabilities, and all business income is subject to personal taxation, basically reported on the personal income tax return. Partnership is also very simple to form. If you act like a partnership, you're probably a partnership, even if you have no agreement. It is best to have an agreement, and you can modify a lot of things that way. If you don't modify your partnership with an agreement, each partner has an equal voice. So let me give you an example. Suppose that you invest $5 million in our partnership business, and I invest $5,000. Well, if we have no agreements, I have equal voting rights with you. And that's kind of a negative thing. So most of the time, if someone puts in $5 million, they're going to want to have more voting rights than someone who puts in $5,000. They can, but there has to be a written agreement to make that happen. Otherwise, we have equal voting rights. Continuity. A partnership is dissolved whenever one partner withdraws. Liability. As I've mentioned before, there is a personal liability for all debts and liabilities, and that's joint and several, meaning that if you're the rich partner and I'm the poor partner, and someone wants to go after the partnership and the two partners, you may end up paying most of the debt or liability if that's the way it turns out. Joint and several means you owe it all, I owe it all, and the partnership owes it all, but any one of us could have to pay all of it. All business income is subject to personal taxation on a partnership. In other words, a partnership doesn't pay the tax. It flows through the partnership and goes to the individuals, and they report basically the business income on their personal income tax return, and they pay the tax on it. Corporation is quite a bit different. It's at the other extreme. There has to be a state charter with articles of incorporation. It exists perpetually as long as it can conduct business. So if a shareholder owner of a corporation dies or the president dies, the corporation still lives on. It is managed by the officers. Those officers are appointed by directors, and the directors are elected by shareholders. And nicely, shareholder obligations are limited to investment. So if I invest $10,000 in stock in Disney, I don't have to worry if someone falls down at Disney and sues Disney. I'm not going to have personal liability for that. I'm not going to lose my home over it. I might lose my $10,000 if stock goes down for some reason, but generally shareholders are protected unless generally it may be in a smaller company, unless the shareholder has signed a personal guarantee, say to the bank, and a lot of banks might require that if the small corporation borrows money, or unless there's a piercing of the corporate veil. Otherwise, I don't have that personal liability. Now, there is an issue with this because there is double taxation with corporations. Although shareholders are taxed only on the income distributed or the dividends distributed. And so it's kind of, you've got to consider this issue. Up here, in a partnership, all business income is subject to personal taxation. Down here, shareholders are taxed only on what's distributed. However, there is the double taxation problem. Corporation is taxed, and then the shareholder is taxed unless they elect S corporation status, and that means it's a smaller corporation. So there's lots to consider, and it's not always as simple as it may first appear in terms of taxation. Limited partnerships basically are created when a partnership agreement and certificate is filed in the public office where business is conducted, and it's dissolved when the general partner dissolves. General partners have total control, and general partners have personal obligation, unlimited liability. Limited partners are only liable for what they put into the company. In that case, again, business income is subject to personal taxation. In an S corporation, you're going to have basically a charter, just like the corporation in the previous slide, and it's perpetual, and same as the previous slide, managed by officers. Same as the previous slide for corporations, shareholder obligations are limited to investment. However, one special thing about the S corporation is all business income is subject to personal taxation. So it's treated like a partnership for tax purposes. But you get the liability protection, so it's kind of the best of both worlds. The thing with an S corporation is it cannot be a huge business, and it can only have individual shareholders pretty much. And so there are some limitations on that. So Walmart cannot be an S corporation, but if you and your father or spouse or best friend start a corporation with two shareholders, an S corporation may be the thing you choose to do. Another kind of medium or middle ground between partnerships and corporations are limited liability companies or limited liability partnerships. You do have to file with the state. If you don't file with the state, these things don't exist, and you're back to being a partnership with that unlimited liability, personal liability. But if you file with the Secretary of State and you do act as a limited liability company should act in terms of the formalities, then you're going to have the liability protection. This is a newer form of entity, and it has some great advantages because it has the liability protection of a corporation, and yet a little bit more flexible than a corporation. So it's a little bit like a partnership in some ways. And also it has that thing where you do not have double taxation in most cases for a limited liability company, which a lot of people like. It's managed by members unless the operating agreement designates that it's going to be a manager-operated or manager-managed business, and the members are liable only for their investment in most cases, sort of like a corporation. All right. So the sole proprietorship, as a review, is the least expensive business organization to create. But it's continued, and the continuity is tied directly to the will of the owner. Sole proprietor is totally in control. The owner has unlimited liability, though, which can be a real negative. It's not taxed separately as an organization. Partnerships requires two or more persons, and they share a common interest in a commercial endeavor. So, you can consider the fact that creation is easier than a lot of the other business organizations. It's easily dissolved when there's a change in partners. Partners have equal voice unless they have an agreement that says otherwise, which would certainly most of the time be smart to have an agreement. And they have unlimited liability. Partnerships are not taxable. Corporations are an artificial and intangible entity created under the authority of a state's law. And there are domestic corporations, which are basically corporations that exist in the state where they're incorporated. Foreign corporations are those that are operating in states other than the state in which it was incorporated. An alien would be a corporation created in a foreign country. Now, corporations have more expensive costs and filing fees, attorney's fees, and so forth. And if you are a corporation that is incorporated in Delaware, but you're doing business in Arkansas, for example, you would be a foreign corporation here, and you do have to be qualified to do business here and do some licensing here. So it can be extra paperwork. Continuity is nice, though, the perpetual existence. Death or sale of stock does not affect the organizational structure. And the control in a corporation is a little different. Shareholders are the owners. They elect a board of directors, and the board of directors hires officers that manage the daily business of the corporation. Directors make bigger decisions such as dividends and those types of things. Officers manage the daily business, and the officers hire employees. As I've mentioned, owners are liable for debts of corporations only to the extent of the shareholders' investment in the cost of stocks, but there can be some piercing of the corporate veil. So if someone is owning a corporation and misusing the corporation by maybe commingling the funds of the individual owner and the corporation, not holding shareholder and director meetings, and so forth, and engaging in wrongful activity, then the corporate veil may be pierced, and in that case, the owners are liable for debts of the corporation. There's something called the alter ego theory, which is used. Basically, alter ego means the corporation is just another way that the individual is doing business without really any separation between the individual and the corporation. And that's used to impose personal liability on corporate officers, directors, and shareholders. So if you're just using a corporation as an empty shell and you're just trying to hide behind that as an individual, there may be a piercing of the corporate veil. Or if you're commingling the funds of yourself and the corporation and not really treating it as a separate person or entity, then you may have a piercing. And that's generally for smaller corporations with just a few owners, closely held corporations, where that can occur. Corporations do have the double tax problem. Profits are taxed at the corporate level, and then dividends are taxed at the individual level. One way to possibly avoid double taxation that you might discuss with your CPA is pay reasonable salaries and have reasonable expense accounts and loans from shareholders and reasonable accumulation of earnings. And some of those things may help you. Also, Subchapter S election may be appropriate to help you avoid double taxation. Definitely important to have a person who is well-versed in tax to advise you on these issues. Limited partnerships includes all the attributes of a partnership, but the limited partners are not responsible for the debts of the business organization. The general partners are personally liable for the organization's debts. S corporations are a way that you can be a corporation and have the liability protection, but elect unanimously and file with the IRS so that the organization is treated like a partnership for tax purposes, meaning that the double taxation that normally exists for corporations would be eliminated. It includes all the legal features of a corporation, and they have to account individual income tax returns for shares of profits and losses. This way, the shareholders avoid having a tax assessed on the corporate income, but you cannot have more than 100 shareholders, and the individuals are basically who are eligible to elect under Subchapter S. LLCs are very popular these days, and they are treated as non-taxable entities. In other words, there's no double taxation. The owners have more flexibility compared with S corporations, and they will have an operating agreement that will describe how things go. And then there's limited liability partnerships, which is kind of like the LLC. They have both characteristics of a partnership and corporation, so you have the best of both worlds. So, when you're deciding about an organizational form, you should review in consultation with advisors. You should consider different factors and costs and weigh those and pick the most suitable form. Thank you very much for listening, and I'll see you soon.